Court is now in session.
Judge Newman presiding. Please be seated.
Good morning. First, I want to address the ruling yesterday overruling the objection by the defense to the state's question of the witness on redirect as to whether he was aware of certain things that had occurred earlier on June 7th involving Mr. Murdaugh, or Murdaugh. In the questioning, cross-examination of the witness by Mr. Griffin, the witness was asked whether he could think of any reason, the gist of it, if he could think of any reason possible why Mr. Murdaugh would commit the crimes he's accused of committing. That, in effect, turned the cross-examination of that witness from dealing with the specific issues in the case to having that witness testify as a character witness for Mr. Murdaugh. Among his other areas of inquiry was his being a loving father, great provider, financially secure, things of that nature, all indicating an opinion by that witness as to the good character of the defendant, either through direct statements or circumstantially through the evidence that was adduced from that witness. In the court's view, that opened the door for the state to respond by asking questions, as the state did. Hence, the court overruled the objection. In addition to all of that, the objection was totally inappropriate. As the court laid out and reviewed with the parties early in the trial, that objection should be made and the legal basis stated. An objection of totally inappropriate is, in the words of Judge Joe Anderson, in effect, no objection at all. That's not a legal basis for an objection. That summarizes the basis for the court's ruling on that issue as to those questions yesterday. And about character type evidence was not only sought by from Mr. Gibson, but also, was it Loving? But also Mr. Loving. And none of that really implicated Rule 404B. One, it opened the door. Number two, is 404A type reputation questioning that the state had a right to respond to per the rules. And thirdly, it addressed an issue raised in the case by the defense. The defense in the case has primarily been the defendant has such a great character that he could not possibly have committed these offenses. That's been a general thread from opening statement throughout. In addition, the defense introduced through that witness, which was also introduced through other testimony in the case by the defendant, that the boating case was a reason for the murders to have occurred, and by the defense inquiring of the witness yesterday as to his knowledge and belief concerning, or his knowledge concerning the boating case, that likewise opened the door for the state to address that issue. And that's the basis for the court's ruling as to opening the door, introducing the boating case, and reputation type evidence that the state had a right to respond. Under Rule 403, yet to be addressed by the court is Rule 404 issues. And those issues will, to some degree, have to be addressed in camera. And I'm wondering if the state has other witnesses to testify as to other things, since we have the jury here ready to go, prior to addressing any other.
Well, we do have first of all, we do have a Snapchat custodian who has flown in that we need to get in so that person can make the flight. Based on how things ended yesterday, I was prepared this morning. We were planning on going forward with some of the witnesses from the law firm, and that's going to, there's certainly stuff beyond 404, but that's also going to put some of the 404 issues squarely into play. So that's kind of where we were planning to go this morning, Your Honor, with the testimony that we have. I can certainly get some more forensic people rolling. I apologize if I sort of misread what we needed to be ready to do, but that's kind of what we focused on last night and are ready to address this morning.
Yeah, well, the court didn't have a lot of time to do jury planning issues, and it might have, the jurors typically come at 9:30. It might have been a better idea had, with greater thought, to have had them come later. But I don't know how long these issues will take to be addressed.
I think with the two law firm witnesses out of the gate, I think once the court has, we could do some very focused in-camera testimony, and I think that for those witnesses, the court can then rule on what's admissible and what's not, and once that's done, then we can get underway with the jury for those witnesses and proceed accordingly. And then, of course, we can certainly have a discussion as far as other witnesses, and then perhaps arrange a time to do any other in camera. But I think setting the table with these two witnesses is going to set the table for many of the issues that, whether they're in or out, that the court has to decide.
All right. Well, first, as it relates to Rule 404, and Rule 404B states that evidence of other crimes or wrongs is not admissible to prove the character of a person in order to show action in conformity therewith. In other words, not admissible to show propensity to commit the crime or a crime, but it may be admitted for certain other reasons, including motive, identity, intent, and perhaps the existence of a common scheme or plan. Additionally, I'll address it later regarding res gestae, but my view of the evidence is that evidence of the other alleged crimes can be introduced in this case to show motive, intent, common scheme or plan. Given the proper analysis as it relates to that evidence being offered. As I indicated earlier, that the court agrees with the view and as expressed by the court in U.S. v. Siegel, 536 Federal 3rd 306, wherein the court addressed the issue of previous alleged crimes involving multiple victims, and that the state should be able to pursue its theory of proving that why suddenly, or why some such tragic, the motive for such tragic an occurrence to have taken place on the dates alleged here. And under the federal rule, it goes on to say that evidence of other crimes or bad acts is necessary if it is an essential part of the crimes on trial, or where it furnishes part of the context of the crime. This state has not adopted that portion of Rule 404B, but the courts have addressed that issue in some of the cases, particularly one that stands out to me as one of my cases, State v. Frankie Lee McGee from Richland County, in which the res gestae was used as a basis for the courts properly allowing certain evidence, including evidence of commission of an earlier crime, the test being whether it logically relates to the crime with which the defendant is charged. Court states in that opinion in the res gestae that one of the accepted bases for the admissibility of the evidence of other crimes arises when such evidence furnishes part of the context of the crime or is necessary to a full presentation of the case, or is so intimately connected with and explanatory of the crime charged against the defendant, and is so much a part of the setting of the case and its environment that its proof is appropriate in order to complete the story of the crime on trial by proving its immediate context, or the res gestae, or the uncharged offense is so linked together in point of time and circumstances with the crime charged that one cannot be fully shown without proving the other, and thus is part of the res gestae of the crime charged. And where evidence is admissible to prove this full presentation of the offense, there is no reason to fragmentize the events under inquiry by suppressing parts of the res gestae. And interestingly, involved in that case, the court held that did not require a 403 analysis. Because the evidence was properly admitted as part of the res gestae, the issue of whether or not a 404B analysis was done was not necessary. And at this point, the court hasn't addressed any particular issue under 404B, but I find that it is admissible, provided that the proper scrutiny is done in relation to clear and convincing evidence and a logical relationship to the offense for which we're having this trial. And additionally, as relates to intent, evidence tending to prove a defendant's state of mind or intent at or near the time of the crime is relevant to establish possible guilt. So there are many areas under which it's appropriate for the court to consider admitting this evidence of other crimes, other bad acts, in a manner that does not address or seek to have the jury conclude that it's propensity evidence, and the court will address all of that as we proceed. Yes, sir, Mr. Griffin.
Thank you, Your Honor. I just want to get some arguments on the record for purposes. As to Your Honor's conclusion that we opened the door by presenting evidence of good character, I would respectfully disagree, and the evidence that we presented was specifically limited to the relationship between the defendant and the victim for which he's accused of murdering. In our view, that is not character witness. That's a factual issue relating to the relationship between the parties. And so I just want to put that on the record. Your Honor puts great emphasis and reliance on U.S. v. Siegel, and that's a federal case. I want to point out that
I gave the site, federal second.
Yes, sir.
Federal second.
The federal site is 536 F3rd 306.
F3rd, yes.
Yes, sir. And it's important to distinguish the federal crimes for which the defendant in Siegel was charged with. First, the defendant, she was charged with murdering the victim to prevent him from reporting fraud, and that's a specific federal statute, 18 U.S.C. 1512 A1C. She's also charged with impending an official investigation by transporting the deceased body across state lines. But further, the indictment alleged a broader scheme and artifice to defraud. And in the indictment, it listed many of the prior crimes that the defendant committed in the federal indictment. And so, and under federal rule 404B, you can prove those up. And then there were others that the court considered they were related to the whole scheme and artifice to defraud. The indictment in this case, Your Honor, is simply on June 7th, 2021, the defendant with malice aforethought murdered Ms. Maggie Murdaugh, murdered Mr. Paul Murdaugh, and used violent weapons in commission of those two crimes. There's no scheme and artifice to defraud here.
You're currently addressing it as if the court ruled based on 404. And the court clearly stated that we have not reached any determination on 404, that the basis of the court's ruling was 403, the voting case, as you introduced through the witness, and opening the door by giving testimony, soliciting testimony of generally good character of the defendant, such that neither of the two witnesses could possibly imagine a scenario under which what would cause this crime to have occurred, and the state is entitled to confront that evidence in the manner in which the court ruled. But you're arguing 404. I cited that for an additional basis to say the court will need to look at all of that as we proceed with evidence of prior bad acts, but the basis of the court's ruling was not 404, but 403, opening the door and responding to the evidence that you adduced.
Yes, sir. I apologize. I misunderstood.
Yes,
Your Honors.
On that rule based on U.S. v. Siegel and overruling your objection yesterday.
Fair enough. I guess I would ask for clarification of where we go from here. Is your intentions to have a hearing outside the presence of the jury on their proposed 404B be evidence?
Yes, sir.
Okay, then I can save all the arguments from there. Thank you.
Yes, sir. And again, with regard to planning purposes for the jury, you said a witness, whatever can be done without getting into the 404 or the court's need for an in-camera hearing, where we need to dismiss the jury for whatever period of time that might be. We can press on with what you have otherwise at this time, and whatever that is what we'll hear.
Yes, sir, Your Honor. Like I say, we have one short custodian, and then I think our next witnesses here would be somebody where we would need to address some of the 404. That would be Jeannie Seconder from the law firm. If you give me one moment, I can to confer with my staff, and we can see if we can get some other people rolling so that we can kind of stagger that and continue to have presentations for the jury during the course of the day.
All right. Are you ready to proceed?
Yes, sir. We do have, again, that custodian witness. Then I think we would have to, we are rolling some additional witnesses, but I think at that time we would have to break and do at least the first in-camera witness. Again, I think that may set the table for a lot of subsequent things. And then we can have some additional work outside of any 404 stuff in the afternoon, Your Honor. But certainly happy to do that, or if you want, we can put up some multiple witnesses on the in-camera here today.
So I think as it relates to each alleged bad act, it must be the court must be informed and proffer and addressed separately. Of course, some may be a series of things occurring almost simultaneously, so that may be a different scenario. But we'll see how it goes. We're ready to proceed with the jury.
Yes, sir, Your Honor.
Raise your right hand and left hand on the Bible. You affirm the testimony about to give the court in this trial shall be the truth, so help you God. Take a seat in the witness stand. State your name again for the record. Spell your last name, please.
My name is Heidi Galore. Last name is spelled Galore.
Please quote. Good morning.
Where do you work?
Morning. I work for Snap Incorporated.
What are your duties there?
I'm an law enforcement operations lead, so I assist with and help manage a team of folks who respond to law enforcement legal process. Sure. Our team responds to legal process submitted to our company, subpoenas, search warrants, that kind of thing.
All right. So you're in charge of responding to search warrants or subpoenas from law enforcement or other legal entities?
Correct.
And briefly, please, what is Snapchat?
Snapchat is an application that was created by Snap Incorporated to help people express themselves. People can connect to their friends, people they know, and I guess you could consider it a social networking type of application.
Is social media another word that could be used for Snapchat?
Yes.
Does it give the ability for individuals to send each other messages?
Yes.
Does it give the ability for individuals to send each other pictures or videos?
Yes.
And in the normal course of this business, does Snapchat keep records if the user so chooses?
Yes.
What kind of records does Snapchat keep?
Basic subscriber information, content that was sent to and from folks, IP logs, geolocation, depending on the settings of the user.
Okay. I'm going to show you what's been marked as States Exhibit 305 and 304. I'm going to ask if you recognize these two items.
I do. Yes.
And what are you holding?
The paper here is the basic subscriber information for the user that was produced in the search warrant.
And what's that CD?
The CD contains the full production of files that was sent to your agency, requested from the search warrant.
All right. And that was a search warrant from SLED
Yes,
that Snapchat responded to?
Correct.
Okay. And you said there was subscriber information on that piece of paper, correct?
Yes.
And is that also located on the CD and the digital record?
Yes. Yes.
And Your Honor, at this time, state would move these into evidence.
No objection, John.
They're admitted without objection.
I'm gonna hand you back states 304. And you indicated that was subscriber information, is that correct?
Correct.
And can you read for the jury the subscriber information for the information on the account that you provided in response to the search warrant?
Sure. The username is listed here. The username is listed here as Paul9499. Common spelling for Paul. The email address listed here is paulmurdaugh7845@gmail.com. This was created, the account was created on Saturday, May 18th, 2013. There's a creation IP, but it's not listed here. Sometimes it's captured at the time of creation of the account. In this case, it doesn't seem to be. Phone number listed here is 803-842-7845. Display name is listed as Paul Murdaugh, and the status is active.
Okay. And when somebody uses a telephone number, for example, to create a Snapchat account, does Snapchat verify that number?
If the user wants to verify the phone number, yes, they can, but it's not required.
Okay. And what about the email? Is that required?
Not required either, no.
All right. I'm going to hand you State's Exhibit 306. This is already in evidence. And I believe this is a CD. You recognize that CD?
Yes, I do.
Have you reviewed the contents of that CD?
Yes, I have.
And what is on the contents of that CD?
It's a video of a subject near a tree, and it's a short video with some audio.
Okay. And did that video, was that part of the full search warrant return that we just talked about?
Yes.
All right. And did you take a look at that video and the records contained in the other CD to determine when that video was first uploaded and first seen?
Yes.
Okay. Well, first of all, let's talk about the upload. Was it uploaded to something called Memories?
Yes.
And can you describe to jury what is Memories? What does that function with Snapchat?
Memories is kind of like a bucket where you can save your data. You can either create a video or some sort of photo on the app itself and save it to your memories so that it's always there when you need it, or you can upload from your camera, your phone, into Memories to then send to folks later, or just have it in there.
So is that a form of saving, like saving something in the cloud?
Correct, yes, it'll be on the server.
All right. And in reviewing these records, did you determine when this account uploaded that particular video to Memories?
Yes, this video was first seen on Memories on June 7th, 2021 at 7:39 hours
Okay.
Eastern.
And does Snapchat also keep a record when an individual sends out a communication?
Yes.
And did you determine in reviewing the records whether, that account sent out that particular video?
Yes, it was sent on the same day, June 7th, 2021 at 7:56 hours Eastern time.
All right. And I'm going to show you, if you look at your monitor in front of you, and I'm going to show you State's Exhibit 306, and see if you recognize it. And did you recognize that video?
That didn't show up on the.
Oh, I'm sorry. Can we get get on the screen? My apologies. Try it again. Yeah. Can you see the what's on your screen right now?
Yes.
All right. And I'm gonna play that one more time. Okay. And do you recognize that video, man?
Yes, I do.
All right. And is that video the video we just discussed that was part of the Snapchat search warrant return?
Yes.
That you just testified was uploaded at 7:39 p.m. and sent at 7:56 p.m.?
Yes.
No further questions.
Morning.
Can we pull up the Snapchat video, just have it frozen on a screenshot? So this is what, or part of what Snapchat gave to the state on July 6th, is that, of 2021, is that correct?
Correct.
So the state had this on July 6, 2021, in the state's possession,
I believe so, yes.
this information. And you testified that this was uploaded at 7:39 p.m. on the 7th of June, correct?
Correct.
Is that exactly when this video was shot?
I can't tell that information from the production.
Are you certain that's not something that could be told from the, perhaps the metadata for the video file?
There was no metadata produced for this production. It wasn't requested, so it wasn't produced.
So if someone were to right-click on this video file and you know, where it has various metadata that pops up on the screen, would we see a media created date?
I don't know.
Well,
I wouldn't know.
let's see if we would. Can you see on the screen the metadata for this file?
Yes.
Does it say June the 7th, 2021 at 7:38 p.m.?
Yes.
And so this was shot basically a minute before it was uploaded, is that correct?
It appears so, yeah.
And I'm sorry if that seems picky, but in this case, you know, every minute and every second, you know, can matter. Does Snapchat keep a list of, and I might be getting the terminology wrong, friends or contacts that Paul would have had on Snapchat?
Yes.
Was that list produced?
No.
And why was that list not produced?
It wasn't requested in this case.
You mentioned earlier geolocation data. Was that produced?
No, not in this case.
And why was that not produced?
I don't believe it was requested.
Is it possible for, I don't know how it works, for some or all of Paul's friends to have access to his location through the app?
Yes, if his settings were, if he made his settings visible, his geolocation visible to his friends, yes.
And would that information about whether that was, that setting was in place to allow that, is that something that Snapchat would have had available to produce?
I'm not sure I'm not sure about that. If you can see that it's actually turned on or off.
Was that requested?
No.
No further questions.
By the state.
No, that's what's good.
Thank you.
Thank you.
Step down.